Hi, my name is Neha Janeja and I work as a consultant for Doctors Without Borders in the area of intellectual property law. I'm going to talk about digital rights management today in this module. And would be throwing light upon the legal protection of digital rights management. The main areas of focus would be digital rights management, technological protection measures, rights management information, DMCA, the Digital Millennium Copyright Act of United States, European Information Society Directive, Indian Copyright Act, WIPO Copyright Treaty, and WIPO Performances and Phonograms Treaty, basically the WIPO Internet Treaties. Here I would talk about the evolution of the digital technology. Rapid evolution in the distribution of media in the audiovisual and literary sector is no more just limited to conventional methods of distribution. There has to be a lawful acquisition of copyrighted work as well as fair and equitable remuneration of the authors. These two aspects are very important because the authors and performers work very hard, and proper remuneration gives them hope and motivation to manage efficiently the distribution of their work as well as secure financial returns proportional to the extent of exploitation of their work at each step of distribution. What is the context of digital rights management? Digital rights management comprises of a set of technical as well as legal instruments which allow the copyright owners, phonogram producers, artists to manage the access to their works very effectively in a legal and ethical manner, establish permissible uses, terms and conditions for the use and equitable distribution of their work in the digital world. Digital rights are manifested in basically three different contexts. First is in the context of IP law, that's called the intellectual property law. Then the context of technological protection measures, in which we have to actually propose anti-circumvention rules to protect the digital technology. And then is the context of licenses and contracts. The limitations occur like in case of an e-book, no copy pasting of content can take place unless the book has been legally purchased by a person. An author can definitely put restrictions to download or transfer the book on different devices as well when it comes to exploitation of his work. So basically digital rights management is about selective exploitation of an artist or an author's work, and effectively with sufficient remuneration to him as well. A digital rights management is generally introduced in 4 different ways as suggested by the following illustration. Packaging. In case of packaging, the digital rights management encryption keys are built into the software. DRM encoded files, that is the digital rights management encoded files, are then made available to the users via web server downloads or CDs, DVDs, any external storage devices as well. License serving and license acquisition involve the authentication of access through various servers to provide access to legitimate users by providing encryption keys, as in the users are provided encryption keys when they log in or they have a code to access the needed technology or the needed document or the content of an author. So it's in the hands of the author to control the access of his information to the user in receipt of some payment or remuneration basically. and all this process is done legally. Legal protection of digital rights management. Digital rights management technologies are protected either by patents or are kept as trade secrets. That is, the authors or the performers or the phonogram producers do not expose their formulae or their writings or their innovation or their creative work to anyone, and they keep it reserved, and that is called a trade secret, or they get a patent protection on their work. It can even be in case of hardware digital rights management technology. Digital rights management technology licenses are used to establish secure transmissions from the content provider to the individual end users. So there is a contract or a license between two parties per se, between the content provider and between the end user. The clauses are designed in a way that directly serve the copyright and security interests of the content providers as well. Advantages and disadvantages of digital rights management. It enables the micropayment schemes where users pay for what they consume, in the sense that if a person wants to access one chapter from an e-book, then he can take a limited subscription as well for a 24-hour subscription to access that content, that particular content, or he can even take a longer membership to access that content and pay a higher price. On the other hand, fair use doctrine is a major concern under digital rights management. These systems use a range of mechanisms to identify and track the activities of end users, and the drawback here is that this hinders the privacy and the rights of the end users. DRM results in a reduction in the freedom of expression as it interferes with scholarship, parody, review, speech, commentary, etc. It also causes a major stifle in the innovation, and the companies do not get the incentives to develop new technologies and interact with the copyright works. Now we are going to talk about the international treaties which govern the digital rights management system, and there are developed countries who have implemented the WIPO Internet Treaties, the World Intellectual Property Organization's Internet Treaties, called the WIPO Copyright Treaty and WIPO Phonogram Producers and Performances Treaty in their own national legislation. WIPO concluded a convention to protect the DRM systems. The formation of two treaties, WIPO Copyright Treaty and WIPO Performances and Phonogram Producers Treaty came into force on March 6, 2002 and May 20th, 2002 respectively. It was adopted uniformly by more than 100 countries, majority being the developing countries. Article 11 of the WIPO Copyright Treaty and Article 18 of the WIPO Phonogram and Phonogram Producers and Performances Treaty state that it is necessary for all the members who are signatory to these treaties to provide legal protection and legal solutions against the evasion of technological protection measures, also known as TPMs, that are used by copyright holders, performers, phonogram producers in order to maintain the interests of the preservation of their technology. Protection against illegal activities such as hacking and unauthorized distribution of copies of copyrighted material is also known as digital piracy, which is also being protected under the legal umbrella of these treaties. Protection of rights management information, also known as RMI. Article 12 of the WIPO Copyright Treaty and Article 19 of the WIPO Performances and Phonogram Producers Treaty obligates the member states to take adequate and effective legal steps against unwarranted and unauthorized trifling of the rights management information, and also in cases of works or copies of works where it has been a tampering of the rights of the author without the knowledge or without his own knowledge. This also includes distribution and rental rights, right to receive payment for certain types of communication to the public. The main supporters of the WIPO treaties are US and Europe. These treaties came into force and have been ratified and being implemented in the different national legislatures of member states in order to protect and balance the interests of the right holders as well as the end users.